Now let's see six instances given. I shall deal with each and every one. So it is not sustainable. What is sustainable? Suppression by the board. Why? Because board has not produced a document, which according to judge I have shown the document was produced, disclosure particular given, but my lord, kindly see as a judge, if the respondent does not, is suppose respondent suppress a document, what's the consequence in law? Petition will be allowed. So, respondent has suppressed a document according to learned judge, which is incorrect on fact also. But what's the for that petition will be allowed by making orders which are not paid for in a petition. Law is right. Let me finish this.
Yes, the paragraph, then you argue.
Okay, very
Second person, please place.
good. The election process, illegality, conducted board is clear. The board, its officials, including its lower in former president, Mr. Manning Potter, I'm told is a one, who is now in custody after arrest by enforcement directorate for transaction of huge money in the recruitment procedure. In which procedure? Lordship doesn't say in the selection procedure of 2016. That's because he was in connection with TATE 2014 selection procedure. And he is not yet he is now released on bail, he has not yet been convicted, found to be convicted. Now, my lord will consider whether it is relevant to consider this factor while deciding the validity of the selection procedure 216. That the president was arrested and in arrest in what? Suppose he has committed theft. Yeah, he arrested for that. And that will vitiate the selection process, a public selection process. He does not say he has been taken in custody because of something wrong done by him in 2016 selection process. Doesn't say that. They come to the next, if I read on. If he said, Lalne just said, if a president is arrested for doing something wrong in respect of 2016 selection process, I could understand the relevancy. No. Then it is mandatory process. Conducted the whole affair as a local club. Now is gradually coming to light by investigation of gradually coming to light by enforcement directorate that jobs for primary school teachers were actually sold to some candidates who had the money to purchase the employment. Similar. Why is any instance given? Then a corruption of this magnitude was never known in the state of West Bengal. But please analyze me. For money, very good. There is no basis for no instance even. I mean, judge has not been able to say that jobs were sold in connection with 2016 election process.
Yes, we have taken note of that.
Yeah?
We have taken note of that.
Yes, yes. Similar, this is paragraph 17. So my humble submission would be in paragraph 17.
This has no relevance. This has no relevance.
Does not make out any case of corruption.
Yes, that was the first.
Of corruption in respect concerning 2016 selection process. Does not make out a case of corruption to 2016 selection process. If corruption happened in respect to another selection process somewhere else, that should not vitiate this selection process. Now I shall come to the petition spoilers. Then paragraph behind the bar, CBI inspection, then befitting that. Paragraph 18 shall I read now? It is a matter to be noted that the board in its affidavit in opposition, while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process raised some niceties of law and some principle of law, but however nice or however laudable these principles maybe this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above sense of law. If the writ application is thrown out on such nicety of law, as this will mean that in the name of preserving the law, corruption would be proceeded, which is a constitutional court can never be keeping in mind the soul of our constitution and constitutional conscience. I must say that in this scam, excellent paragraph. Now it has got 2 points. Let me analyze what the judge holds. 2 points. Firstly, that there is an allegation of corruption in respect of this selection procedure 216 in the writ petition. I say it is none. There is none. I show you. And second is, my lord, a very, very fundamental question of law. I hope Lordship will consider whether agree or not with this. That the sense of justice is above sense of law. Justice without law. Rule of law has no place in my country. Basic structure of constitutional rule of law. And can you deliver justice contrary to law? This is the provision of law who will calculate everything in the highest appellate court of the state. Will examine this. Will the sense of justice above the law? The court should deliver justice regardless of law. This is the provision of law. How drastic it is. It doesn't require an argument to be rejected. And this is the basis of the judgment of a learned judge of this court. Now let us see first thing, what the allegation of corruption in the writ petition regarding this. Can you take the writ petition, volume 1, see paragraph 17, page 42, volume 1. And see charge of corruption in respect of what?
You're placing from your paper book or from 873 paper?
Huh? Both. I'm leaving both. I shall tell you when going on both. Both paper book, depression, volume 1, page 42, paragraph 17. This is the only paragraph we have found. The alleging corruption. The scam